This session is organized by lexauxilium.com in association with juscorpus. Before beginning with today's session, I would like to welcome our guest speaker for the evening, Advocate Rahul Tiwari, sir. Before beginning with the session, I would also like to give a brief introduction about our speaker for today's session. Advocate Rahul Tiwari had completed his legal education from New Law College, Bharati Vidyapeeth, Deemed University, Pune. He has obtained his LLM with a grade point of 8.35 GPA and was being declared to be a distinction holder. He had specialized in cyber crimes and economic offense. He is a judicial service aspirant with a strong passion for legal research and public speaking. He has presented about 25 research papers in various international and national seminars in Denmark, NLSIU Bangalore, BHU, CNLU Patna, IIT Hyderabad, NLU Odisha, IIT Allahabad, Delhi University, and has 7 unpaid publications in prestigious journals, including the UGC approved one. Apart from legal practice and research, he loves to teach students. He has also been invited as a guest speaker on 4 webinars so far, where he had taught the law students about the basics of criminal and constitutional law. Sir has also been invited in National Law University, Delhi, as a resource person in a national conference on protection of women from sexual harassment at workplace. After passing out from his law school, Sir has worked on the famous Babri Masjid demolition case under Advocate on Record, Mr. M.R. Shamshad, as a research associate, and is currently working as an associate at a litigation firm, namely Lamba and Lamba, which is situated at Gurugram, and is also practicing in Delhi High Court, District Courts, and Gurugram District Court. His areas of interest are criminal law, cyber law, security and artificial intelligence law, and corporate litigation. Sir has also a keen interest towards reading, researching, and loves swimming. Sir follows the philosophy of Gandhi and Ambedkarji in his life, and he loves horse riding. So moving forward, we will also discuss a bit about today's session, that what are the points and what are the areas which we are going to cover in today's session. So the main focus of today's session is to address the issue of domestic violence, which is omnipresent in every society, irrespective of the fact that it's an Indian society or a Western culture. The societal mindset, although with time has progressed, but still there are a lot of instances where women is not viewed on an equal parallels to men in most part of the Indian society. Marriages in India are governed by the Special Marriage Act of 1955 and various personal laws according to the religion of the person. Even after having stringent laws against domestic violence and constant support of Indian judiciary and Indian constitution towards the maintenance of the divorced women and other unprivileged women, the ground reality portrays a very different and regressive picture. So in today's session, we will highlight the gap between the laws and implementation of such laws, besides covering the social aspects of divorce, domestic violence, and its impact on the women and the children who become vulnerable in such circumstances. The speaker in this webinar will also show how domestic violence is an issue across every religion and caste, and how Indian society has yet to come up with reformation in the mindset in order to provide equity and fair access to justice for such women. So without taking much of your time, over to you, sir.
Hello everyone, my name is Advocate Rahul Tiwari, and today I am going to talk to you about a very important subject, which is the domestic violence. See, when we grow up, it is an issue which we observe everywhere, whether in our family, whether amongst our relative, or near to you, you observe these kind of things in your real life. So at least nobody can say that no, I have never witnessed domestic violence in my life. Okay, so it is such a thing which has ingrained our society, and we have to, and like even after having so many laws, even after so many laws, we don't have anything to suppress these things. And even when I was going through the question, one of my junior has asked about, and in fact, two of the participants has asked about the domestic violence and the COVID-19 issue, which was, observed that in the COVID-19 period, the domestic violence had actually increased. So what is the reason that even after so much of education, so much of advancement, so much of awareness, so many NGOs working on these, the issue of domestic violence never goes down. And it's my observation, and you can also see it when you look into the NCRB report, National Crime Report Bureau. You will find the highest number of criminal complaint is filed under the section 498 of Indian Penal Code. Okay, so this is something, we know it exists. We have laws for it. The laws which protects the victims, the law which is also misused, I'll accept that also. Okay, but you know, this is something which we actually take very casually. So that was the reason I thought that we should take up this issue. It would have been very easy for me, to take up a very technical issue and talk about that. But the organizers had contacted that most of you are students, and also most of you are from non-legal backgrounds from other universities. So it would be better for me. So I thought it will be really better that if I should choose a topic which connects everyone, like marriage. Even if you are of any religion, of any caste, the marriage is bound to happen. I mean, if you are one of the minuscule person who doesn't want to get married, it's something else. If you take the consideration of marriage, then obviously after marriage, the divorce rate are going high. And when you see a lot of authentic NGO reports, then you will find that the domestic violence, especially in India, experienced in more than 50% of the household. So in every two women we meet, one faces domestic violence in her household. So this is something, which exists in our society. And the irony is we take it very lightly. So, I have designed this webinar in such a way that, I'll deal with the domestic violence issue. What are the laws for the domestic violence? What are the causes of the domestic violence? Is the domestic violence just a factor of people of a lower background, low income group, or it is something present in every income group or every class or every religion? Then I'll move about what are the factors of domestic violence, what causes domestic violence, what are the impact of domestic violence, what are the laws, what are the loopholes, and then I'll move forward that about the divorce part. And again, a post-divorcee, if you see the chronological order, see the first is the domestic violence. It becomes the ground for divorce. Post-divorce, the wife can definitely should and actually they ask for the maintenance, they get the maintenance, and this sequence goes. So after this, there will be my personal observation on the plight of the divorced women in India. Like, before starting, I would like to address that most of you have seen the news of Miss Komal Kataria. I'm forgetting his name. Her name. She was a woman. She was a teacher by profession from Gujarat. She got married. She was thrown out of her household. Okay, she was thrown out of her household due to dowry demand. She was regularly harassed. She faced domestic abuse in her matrimonial home. Ultimately, she left the household. She prepared for UPSC. She cracked the exam. She became an IRS officer, assistant commissioner of income tax, or maybe GST, but she's an assistant commissioner. But when we see, not every woman is, in our country is that capable of that caliber, or not everyone can, afford such kind of hard work to achieve that level. And what is the reason? See, first of all, the reason is in our upbringing. We always, even if you see in your household, if there is a son and a daughter, the son always gets the more privilege. the daughter gets the less privilege than the son. Okay, so from the start, the daughter is given less privilege. She's 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 brought up in such a way that she is subordinate to men. She has to do this, she has to do that. So ultimately the confidence goes away. I've seen a case like even today, when you see the average age, when you go past the metro areas, even today in the rural areas or tier 3 cities where the maximum population of our country resides, the average age of marriage is 17 to 22. Okay, so a person, there's a woman who was brought up in a conservative household, which we should accept that we as a society is still a conservative society. Okay, she is brought up, she is married at the age of 20, she is barely 12th pass, or you can say a simple graduate, which have got no value. She gets married. Then after a few years of marriage, she she faces domestic violence, and if she gathers the courage to leave the husband, after leaving the husband, where will she go? If she has a child, is she educated enough to support herself? Is she educated enough to uh, to fight back and to achieve for what she deserves? No, because from the start we have killed the confidence. So that was the reason that I thought that we should take a topic which is of more from a legal, it should be of a, more of a social relevance. And that's why I said that we should, after discussing these laws, we should also discuss about the what is the role of Indian society towards the divorced women. We stigmatize them. We see, we put the blame on the divorced woman about that she has broken her marriage, and obviously in our country the marriage is given so much of importance, and the woman getting out of an abusive marriage is unacceptable to the society, and women staying in an abusive marriage is acceptable. And that's the hypocrisy and the irony of our society, and we have to accept it, because until unless we don't accept the fact which exists in our society, there is no scope for improvement. Okay, so moving forward, see, when we see the history, I'll just wrap the introduction part in next 2-3 minutes, because the syllabus is long and I have to cover in the limited number of limited time. So when we see, if you read the history of any other civilization, either that civilization has vanished, or it has been from the early man, from the village society to the feudal society, then they experience the dark age, and then they reform themselves, and then I'm talking about the western society, and then they progressed. So the graph has gone like this. Our society, when we read about the Vedic period, when we read about the Vedic period, we get so many examples that women was treated equally at par with men. Okay, she had the right to education, she had the right to choose her life partner, and one of our most important god, Lord Shiva, to whom even I'm a big devotee, Lord Devota made his half the body of a woman to show that my wife Parvati is my better half. And from there the concept of Ardhangani started. All are important function, if we see in the Indian society, whether it's money, the goddess of money is Lakshmi, goddess of knowledge is Saraswati, goddess of power is Durga. So all the important thing, we give so much of respect to women. And when we come to the at present the Indian society, they are the worst sufferer and the most vulnerable group. Okay, see, that's the irony. And when we see in the Vedic society, we had such a progressive and open society, you know and then we went like this, and then again the dark period come about the sati widow, no widow remarriage, no child education, child marriage, and now we are moving like this. So all the societies has moved from bottom to top. We were at the top, we went down. We should not blame anyone except ourselves. eh? And we were at the top, we were such a progressive society, then we went down, and now we are moving forward. But the pace actually frightens me. Like when we read all the whatever happening in the news, we have seen what's going on in the media about the rape cases and all. So what is the rape case? When we see the crime against women, it is nothing but an extension. Please, all the judicial and UPSC aspirant, there are a lot of students who have personally messaged me also. See, whenever you want to describe the crime in society, it is a crime against women is nothing but an extension of what we do to our women in the house. For example, there is a woman going in the street. You look into that woman and you say, oh, wow, she's such a beautiful woman. Okay. You are an educated person. You will see the woman and you will just ignore it. The person who is not educated, he will see that woman, he will attack it. But the starting part is same. So that's when, and that is the reason when Dr. Bhimrao Ambedkar, what he did, he just codified the first time in the Hindu law, and when there was so much of uproar when he brought the Hindu code bill, which ultimately gave the real right to our women, and ultimately I'll start now to women. He was so much, he was, totally boycotted, and he was saying that he's anti-Hindu and stuff. He did nothing. A Hindu code bill by Dr. Bhimrao Ambedkar and Jawaharlal Nehru is nothing but a codification of our Vedic period. Okay. So now I, Rahul Tiwari, will start the webinar. Okay. So just try to remember these things that, if we want to move forward, first of all, we have to change ourselves. Like, always remember this example, like, before you curse a person who has committed a crime against a woman, first ask yourself, like, what do you say in Hindi, that क्या आपकी नजर सही है एक औरत के लिए? एंड जब तक आपकी और नजर सही नहीं है, तो आप अपने लाइफ पार्टनर को कैसे ट्रीट करेंगे, ये आप भी जानते हैं, हम भी जानते हैं. So moving forward, what is a domestic violence? Domestic violence means violence between two domestic partner, according to section 2 of Domestic Violence Act. Domestic between two partners, male and a female, and now when the homosexuality has been decriminalized, two adults who are living in a domestic relationship, which is either a marriage or they're living together, or is in a relation which is equivalent to marriage in a shared household. Shared household can be a household where they are living on a rent, चाहे वो किराए पे रह रहे हैं, where it is jointly owned, चाहे वो उन दोनों का खरीदा हुआ है, where the owner is one person, चाहे वो एक आदमी कर रहा हो. हर वो दो अडल्ट जो एक साथ रह रहे हैं, उनके बीच में हुई हिंसा को हम डोमेस्टिक वायलेंस कहते हैं. The domestic violence is nothing but a violence between two persons living in a domestic relationship under a shared house, as defined in the Protection of Women from Domestic Violence Act 2000. How many types of violence are defined under this act? There are three types of violence. Means basically there are two types of violence defined: physical and economical. But when we see the other extended form of violence, it is also the mental violence and the emotional violence also. Which emotional violence is nothing but an extension of mental violence which comes out. What is the part of physical violence? Physical violence is nothing but, now I'll go into the detail. I've just made a PPT, and all those person who will be getting certificates, I'll share the PPT and everything with them. Okay, because it's a part of my research now, so obviously I cannot share each and everything in detail. So, what are the forms of domestic violence? First form is the physical, as defined in the DV Act of 2005. First form of domestic violence is the physical violence. Physical violence is nothing but like hitting, pushing a person towards a wall, kicking, or causing injury to a person, giving threats, and beating in a way that it causes hurt to that person is all part of physical violence. And I don't think I should go on explaining about the physical domestic violence, which everyone is aware of. Moving forward, another form is sexual violence. It is also a part of domestic violence, and here I would like to uh, give you an very example of a judgment. It's a very important judgment. Just wait. Yeah, it's yeah, like injury of the private parts also uh, is also a part of physical violence as held in the Ashok versus Santosh case, where and physical violence is something which can be said to be gender neutral also, because in this judgment the wife during the course of sex, wife pulled the flaccid penis of the husband by mistake, and whether it was by mistake or it was deliberate, but it caused the injury to the private part of the another person. So we have covered now the sexual violence. Now the psychological violence. Psychological violence is nothing but the forms of mental violence, mental cruelty caused to the person. And mental cruelty can be caused in many ways, like abusing a person, making unnecessary dowry demands, making unnecessary, neglecting the person, filing false cases against the person, or falling and creating an embarrassing situation for that person, verbally abusing that person, neglecting by all the family members towards that family member. So all these things becomes a part of uh, physical violence, which is covered in the Domestic Violence Act. Lastly, last form of violence will be the economic violence. Economic violence is like ensuring the person that she doesn't do a job, making sure the person that she does not get the money at the time, the husband not giving her money, depriving her all the monetary benefit, or taking away her jewelries, which were basically owned by the woman or the father of the woman, or she has purchased, or she has got that valuable items as a gift. So these are the forms of the domestic violence. Now moving forward, what are the reasons responsible for domestic violence? First of all, basic is the lack of education. And in the lack of education, there was a participant, Nitika Singh. Nitika Singh had asked about the sex education. So yes, sex education is also a part of education which is not given properly in our education system. So first of all, starting with the lack of education, one reason responsible for domestic violence, here I will divide it into two parts. First, the individual reasons which are responsible for the domestic violence, and the second will be society reasons which are responsible for the domestic violence. First is your lack of education. Lack of education doesn't mean that a person is an illiterate who, all those who are illiterate person will again commit crime against women. In that case, we will never see, educated persons committing the crime of rape or dowry, so this is some education means when there is a lack of reform in your mindset and in your mentality. So if you are an IIT engineer, or like, okay, fine, take an example of mine, like you are an LLM, you are a PhD in law, and you don't respect women, you don't respect your elders, you still value the patriarchal feudal mindset, then what is the worth of your education? Nothing. Because again, what will you do is you will carry the same old pattern which didn't develop during the Vedic period, but during the medieval period, which is also known as the Dark Age. The medieval period, all those even in the UP judiciary, it can be asked, the medieval period is from the 10th century to what medieval period, early medieval period will be 10th century to 13th century, and the dark age period is from 13th century to till the battle of Plassey, or we can say till the independence. And from the independence, we generally see the modern period, or from the battle of Plassey. Okay, so these practices started with the medical period, which the patriarchal or the feudal mindset people propagate. So what is the value of your education when you can't even respect to women? So lack of education, again poverty. Why? Because of your poverty, there's the frustration grows in any person, and women being an easy target to to vent out your frustration. Again, the person being frustrated in poverty due to many other reasons takes his frustration out on the woman and mostly on his wife. Moving forward, drugs and substance abuse. Obviously, drugs and substance abuse are one of the biggest reason for the domestic violence. When you will see in many cases where the husband is a drug addict, or he's an alcoholic, there are high chances of domestic violence, because after taking drugs or alcohol, there are high chances that he will start beating his wife in the state of insanity. Again, lastly, the feudal mindset. The feudal mindset, again, where you treat women as an object. You treat uh, you treat a woman subordinate to yourself, again, and there you don't give them any right. And again, if not physical, you do the uh, mental or the economical violence on the women. Now, the societal factor. What are the societal factor which are responsible for the domestic violence, which has so much of widespread in our society? First of all, gender mobilization. Like, we have a fixed thing that men should do this, women should do this, then defined role of a woman which they are taught, and then expectations, and then the belief, their custom of marriage. And obviously in most of the customs, the dowry, even, and dowry is something, whether you go in the South India, or you go in UP, Bihar, or in Rajasthan, or in Haryana, or in Delhi NCR, you will see dowry practice is prevalent, and it becomes one of the biggest reason for the domestic violence in future. Because at the start of a domestic relationship, you are financially putting pressure on that person. Now, and the economic reason, obviously, women not being trained properly, women not being given proper education, she being dependent on her husband, obviously opens the door for the domestic violence. Limited resources for the women to earn themselves, limited access to cash and credit, discriminatory, limited of discriminatory mindset of the people at the position, who don't give them job, or if they give them job, they don't give them proper salary, or salary half, they don't get the equal salary to the men. So these are the economical factor. Lastly, the legal factor. Obviously, we have less than 10% of legal representation in the parliament. Again, the society is responsible. The law regarding divorce is, on book, when you read, it is very strong, but in practice, it obviously, the judicial delay causes more and more trouble for the women, which we can say, the regarding maintenance. Again, you can see the triple talaq bill, and the uh, child custody cases. Again, the legal cases goes, and women not being educated are unable to fight the cases for a longer period, and hence they, in due to exhausting by all their options, they return to their the old they return to their old domestic matrimonial home. Moving forward, and now, what are the effect? Because because these kind of domestic violence creates such a fear in the mindset towards the women. What did it do? That it leads to the more serious crimes of female infanticides. Now, because of the domestic violence, the woman is staying in a marriage because the preferences for the child. Obviously, preferences for the child, then a woman is, most of the time, she is subject to, either abort the child, or the the girl child is, thrown away, or killed after the childbirth. So these are the further effects of the domestic violence, which not only affects the person, but also affects the newborn children, or the children in the womb of a woman. So now moving for, and what are the another reason? Like, we have India, the conviction rate is, when is just 26%. So obviously the low rate of conviction, the judicial delay, it further gives confidence to the offenders to, because they know that the laws, especially for, you know, they can, although it's a bailable offense, but because the woman has lack of resources to fight a legal case, they know that they can get away very easily, hence, and obviously the 26% of conviction rate further creates a much problems for them. Now moving forward, and now most of the time when we see what is the impact of domestic violence on the children, first of all, when we it has been observed, and when you can look into any NGO reports or any reports, any research papers, that the child child being brought up in an environment where he or she sees her mother being regularly beaten or in an abusive relationship, it tends to create his psychological impact. And obviously the child creates the rebellious attitude, he creates hallucination, he has the low self-esteem, he has the isolation problem, he has the insecurity problem, obviously, and he creates a very terrible image for himself. He wants to, his academic performance are affected due to such thing. And most importantly, such children are more prone to and vulnerable towards crime. And these are the children who are attracted more towards crime, because they see, because they are seeing the violence at their home and the frustration being created, and crime and alcohol, they develop the alcohol problem, because alcohol or crime, they see escape route to avoid such things. Now, like, moving forward, uh, obviously, is domestic violence gender neutral? 80% of the time, yes. I would say that, yes, in 80% of the time the victim is a woman. But now, as we know that all the section of 498A or the dowry laws are heavily misused, it, when we read the NCRB report, there are every year 9,000 women are killed due to dowry. Okay, and the arrest made on the dowry complaint, 80% of the dowry accused are acquitted. So it clearly shows that dowry is a problem still prevalent in India, but the dowry, sorry, but the dowry laws are also misused. And hence, right down, the first important judgment came in 2014, named Rajesh Sharma versus State of UP. In that, Supreme Court taking cognizance of the matter that the dowry laws are being misused. Hence, they gave the guideline to the police that before arresting the person, they should go with every guidelines uh, of of the pre-arrest procedure to ensure that they don't arrest. There should be an immediate arrest, and they don't arrest an innocent person, and they should comply with all the procedures of the arrest from section 41 to section 60 of the CRPC. And obviously in 243rd report of the Law Commission of India, in the Law Commission of India, it was also noted that section 498A is heavily misused. Now, without wasting much time, let us discuss what are the laws for the domestic violence. Okay, then the Domestic Violence Act was passed in 2005. It defined the domestic relationship. Domestic relationship. What is domestic relationship? In section 2, subclause F, subclause F, it says that it's a relationship between two adults living together in a relation of marriage with their family, or in a relation similar to the marriage in a shared household. The shared household is defined under section 2, subclause S, which says that in a shared household is a place, or a property on whether on rent or purchased by jointly or by one person where two persons live together as a domestic in a domestic relationship. So if the and in section 3, all the of the domestic violence act, all the form of physical, mental and economical cruelty has been defined. And when you move forward, like there are many reliefs has been given, and all the procedure has been explained, and I will throw some lights on that. See, in domestic violence, whether people get confused that if the domestic violence is being taking place, then a person should file a complaint against for section 498A or in the domestic violence act. See, this is nothing. When you go and file a complaint in a domestic violence act, what you do is you file a complaint against in a magistrate court of a GMFC or a if when you go and file a complaint in Delhi, you go and file in a metropolitan court, because there is no GMFC court in Delhi, and outside Delhi you will find the GMFC or JMIC court. Like in Haryana you have JMIC, and in other state you have JMFC, Judicial Magistrate First Class. So there you file the domestic violence complaint under section 498A. Obviously, I was asked one of the panelists in the questionnaire round yesterday, because this webinar was scheduled to be yesterday, but now due to some family issues it got rescheduled to today, that whether the family court has the jurisdiction it has the jurisdiction over domestic violence cases. So the answer is no, they don't have a jurisdiction over the family. The family court has, first of all, understand, under 498A you file a criminal complaint. In family court you file a divorce case. So divorce case is a civil case, domestic violence is a criminal case. So both the case cannot go in the same court. Okay, so although the Bombay High Court in the Hiten Mehta versus Ashika Mehta in 2020 recently, last month, they allowed the family court to hear the domestic violence matter also. But in the general practice, the family court, it was asked by the retired Mr. Nagendra Sharma ji. So the family court does. The family court doesn't have a jurisdiction in the matters of domestic violence. Okay, so you file a criminal case, and the criminal trials take place under section 498A. Okay, and for what does 498A says? 498 says that the cruelty done to a wife by her husband, or her in-laws or the relatives of the husband. Okay, and the cruelty can be in any form, whether physical, mental, or the dowry, or the demand. Where the demand can be unreasonable demands also, the dowry demands also, uh, or abating the person to commit suicide. It is a non-bailable offense. It is also a non-compoundable offense. Non-compoundable offense means where there is no scope of compromise. And I'll read out few judgments we have taken out for you, like in Prakash Kaur versus Harjindal Par in the year 1999, and in Shobha Rani versus Madhukar in 1988. See, I'm going a bit fast, but you will see when you see the video again, you can note down the cases. Okay. So in both the judgments, it was held that unnecessary demand of dowry or any unnecessary demands also amounts to domestic violence under section 498. The mental cruelty part. The mental cruelty part, in the famous case of Rupali Devi versus state of UP in 2019, it was held that if the in-laws creates an adverse effect on the matrimonial home of the wife, it also amounts to the mental cruelty under section 498. The state of drunkenness is also the part of domestic violence under section 498. It was which was held in Rita versus Brij Kishore in 1984. Again, before discussing the mental part, obviously the physical cruelty, like beating your wife, is also is also domestic violence under Section 498A. It was held in Rishi versus State of Haryana in the year 1985. And but here I would like to create a difference. In the State versus K. Sridhar, it was held that if there is an unhappiness between the couple, between the husband and wife, then it is not a domestic violence or uh, the cruelty by the husband on the wife, because cruelty is something when one person causes physical, mental or economical cruelty on another person, and in the state of happiness there is a domestic relation between two person, and both of them, due to their lack of differences, are not happy with each other. Now again, obviously section 498A becomes an important ground for divorce, and if a person commits suicide due to the unnecessary dowry demand, then obviously section 498A is also read with the section 113B of Indian Evidence Act. Again, the court is this is as I have told you, it is tried in the report of JMFC. It is non-compoundable, and it is a non-bailable offense. Now important question is, see, if there is an offense, okay, if there's a domestic violence being taking place between a husband and wife, then who can file a complaint? Then the answer is simple. See, I'm explaining the 498A, and after this I will explain the few important sections of Domestic Violence Act 2005. Then I'll move forward with the cruelty part in section 13 of Hindu Marriage Act, and then I'll take the questions. Okay, so just a second. Yeah, I was there. So, who can file the Domestic Violence Act? Any person, whether it is the relative of the wife, the children of the wife, the children's, or the friend of the abused, aggrieved person, or any other person who sees the domestic violence being taking place. Also, a government servant also, they can go and file a domestic violence case in the police station. So it is not that only the woman is going to file a domestic violence. Obviously, if the person has the sufficient evidence to show that the domestic violence is taking place in anywhere, he can go and file a complaint, provided it shouldn't be a false complaint. Okay, now obviously the procedure of filing the domestic violence case is simple, which is defined under the CRPC. There's nothing new in that. It's just that I wanted to explain you the background of the domestic violence, the cause and effect, and why it's take place, and obviously the important section of 498. Now, obviously, it has been custody of the children. Obviously, yes. And now I'll move to the few important section of the Domestic Violence Act. See, Domestic Violence Protection Act of 2005 was the first act which specifically dealt with the issue of domestic violence. Apart from filing a complaint in section 498A of 498A against the husband or in-laws or relatives, it had other features also which came as a rescue to the victim, which is that section 19 also gave her right to residence. Section 19 of Domestic Violence Act gives the right to residence. Section 20 of Domestic Violence Protection of Domestic Violence Act gives allows the court to give monetary relief. It can be in the form of maintenance, or it can be in form of interim relief. Section 21 talks about the custody of the children. Section 22 allows the court to provide compensation to the victim, and section 23 again specifically allows the court to provide interim relief to the victim. Now, after covering these, and more importantly, it was the first time in the section Domestic Violence Act which gave the right to the court, and also to the government, to form a protection officer who on the behalf of court, who go and investigate and tells the court everything, who makes the detailed report. So this was the first of the one of the most progressive act made for the domestic violence. And interestingly, it was the Domestic Violence Act which further gave the chance to the Supreme Court of India to make their own judicial interpretation and legitimize the live-in relationship. See, what happened is, in most of the cases, what happens that the parliament makes a law, and there are on many aspects where the law becomes silent. Like in Article 21, what happens is that Article 21 basically says the right to life and personal liberty. But later on, due to judicial interpretation, now we have right to privacy as the part of right to privacy as the part of Article 21. Right to education as the part of Article 21. So it opened the door for the Supreme Court, to see and legitimize the live-in relationship. And it was, in the case of Indra Kumar versus V.K. Verma and Khushbu judgment of Khushbu or in 2008, or whether it is the Veluswamy judgment of 2008, the Khushbu judgment of 2010, where the Supreme Court interpreted the terms of domestic relationship and shared household, and it further went on to legitimize the live-in relationship in India. So this was the act made for the protection of women. And it not only provided the protection of women from domestic violence, it also went on to further legitimize the live-in relationship. So again, it's an important question that if anyone asks that which laws further legitimize the live-in relationship, it was the protection of women from domestic violence. Now, quickly looking into the section 13, subclause 1 of 1 and 2 of Hindu Marriage Act, which talks about the ground for divorce. And in the ground for divorce, we have we have a lot of grounds like cruelty, conversion of one person into another religion, mental disorder, desertion, or bigamy, like the Sarla Muddal judgment. So these are the grounds for divorce, and I'll explain. I'll explain very quickly. Like physical cruelty, like beating. See, now we have to understand between the crux of 498A and section 13 of Hindu Marriage Act. 498A simply talks about the domestic violence domestic violence happening to the wife, and section 13 talks about the cruelty, okay, which forms the ground for the divorce. 498A does not break the marriage, but section 13 makes a ground for divorce which dissolves the marriage, like physical cruelty, like beating, causing injury, as held in Kaushalya versus Vishkaram in 1961. It was held that physical cruelty is one of the biggest grounds for divorce. Now, if a person changes his religion, like there is a Hindu person, he has a living wife, he went on to convert into another religion to marry someone else, then it was the famous judgment of Sarla Muddal, and I've answered to one of the participants also regarding that form of marriage will be considered as null and void, and the person will be prosecuted under the bigamy law under the section 494 of Indian Penal Code. Okay. Now the mental cruelty, like harassing, negligence, like Srinadhacharya versus Vasanta in 1970, it was held that causing mental cruelty is a ground for divorce. Putting false accusation or lowering the image of a woman, putting the victim, whether you can say the victim blaming or raising finger at her character, spoiling her image, and speaking ill will about the character also becomes a ground for divorce. It was held in Saptami versus Jagdish in 1970. Again, the dowry demand is a ground for divorce. The false criminal charge, the drunkenness, as I have held, which are punishable under section 498A, also forms a ground for divorce under section 13 of 13 subclause 1 of Hindu Marriage Act. Also, most importantly, refusal to have a children, as held in Jyotis versus Meera in the year 1970, also forms the ground for divorce under the cruelty. Birth of an illegitimate child is also a ground for divorce, held in Madan Lal versus Suresh in 1983. Okay, so these are the important factors we have important factors which we have discussed. So now we have discussed about the Domestic Violence Act 498A, uh, the ground for divorce, and the Hindu Marriage Act. And again, when we see the last year triple talaq bill, which has null and void, which has simply rejected and made the law on the principles given by the Supreme Court, although there was some sort of reservation which the government should have looked into. But the talaq, the instant triple talaq has been declared uh, declared null and void, and now the woman can prosecute her husband if she gives her triple talaq. And also, it was my personal observation that the Domestic Violence Act 2005 should have been amended, and the triple talaq clause should have been added, so it would have made much sense rather than the triple talaq bill. So here, because there you don't end the marriage, and in the bill you basically end the marriage. So now we are done with the domestic violence, we are done with our ground for divorce. Now the important part, I'll very quickly cover it up. It is the section 125 CRPC. So section 125 CRPC says that uh, it orders for the maintenance of wife, children, and parents. If the court finds that if the wife after divorce is unable to maintain herself, if the illegitimate or legitimate children are minor, or if the parents are old and they are unable to maintain themselves, then in that case, magistrate orders the person, if they find that he is capable and he has the sufficient means, to give them monthly allowance. So earlier, when this law was made in 1973, it was all. See, we all know about the Shah Banu case in 1986, where the court ordered to rupees 500 rupees as a maintenance. So earlier it was 500 rupees. Now, when we read the Bare Act or any law, the 500 rupees has been, the clause has been removed. And when the CRPC was amended in 2001, it was uh, instead of writing the rupees 500, it was replaced with the word, I'll read it out for you, that monthly allowance for the maintenance of his child or such child, comma, father or mother, comma, at such monthly rate. So now at such monthly rate has been written in place of rupees 500. And now even I have seen the divorce case in my family. In most of the cases, the ITR, your income tax filing, is taken into consideration before while commuting the amount of maintenance, or the quantum amount for maintenance which should be given. So it is your most of the time the ITR, because ITR actually shows your obviously whatever you are earning, you can may always manipulate the obviously the manipulate the funds, but the ITR is something you willingly declare in front of the government of India. So obviously, and the court also allows that monthly payment can also be, it can be the monthly payment post divorce, and the court, the magistrate, has the right to also has the right not only to uh, allow the maintenance under section 125 after the divorce, but during the proceeding of the divorce, if he finds out that the woman is unable to maintain herself, and the woman needs urgent financial help. And obviously, if the person does not comply, section subclause 3 says, if the person does not comply with that order, then he faces the imprisonment part. But there are certain exception, and section subclause 4 of 125 CRPC and section 5. So subclause 4 says that if a wife has willfully left the husband, or if the divorce happened due to adultery. Third, if the divorce happened due to mutual consent, then in that case, there will not be any maintenance provided to the wife. But if the divorce, like one of the person had asked that whether a working wife can claim maintenance or not, I gave her a example of a judgment also, and I have told that yes, uh, working wife can definitely uh, ask for maintenance, as it was held in the Shailja versus Kobna, AIR 2017. It was held that even if the wife is educated and earning, and if the ground for divorce was cruelty, okay, if the ground for divorce was cruelty, she can ask for the maintenance. Okay, and in certain cases, the court has also allowed that if the wife is estranged, has deserted her husband, and in some financial emergency, if she needs money, then the husband has to maintain his wife. And obviously, living separately. And obviously, during the court, last subclause says that if they are living separately, and if there is mutual consent, and if in such and before the magistrate has ordered the maintenance, then he can also, according to the last subclause, he can also cancel such orders. Okay, now moving forward, and I will just read out few judgments for you that in one of the judgment, obviously I have read the Shailja versus Kopana, and another judgment which was very important, that if the person is are living together as for a considerable amount of time, then also the wife, and if the wife is extremely poor, and if the female is extremely poor, cannot maintain herself, then also, as held in Rajati versus Ganeshan, AIR 1999, she can claim the maintenance. And lastly, obviously, if there is if the divorce proceeding is going on, and uh, the court orders the restitution of the conjugal rights, orders the wife to go and live with her husband, then it was Miss Nishta, this was for you. You had asked the question that apart from the mutual consent, adultery, and mutual consent and adultery, what are the other grounds where uh, the husband can refuse the maintenance? It's the judgment Hemraj versus Urmila Devi, 1997, that it's a ground that if a court orders to comply with the conjugal rights to the wife and she can be denied the maintenance. Okay, and obviously, if the in lastly is according to Hindu right, obviously, it's one of the important judgment for the living relationship, that if there is a marriage taken place between a husband and wife, and the husband started living with the other woman, and the woman is not aware of her previous marriage, that he is lawfully married in such condition, as held in Yamuna Bhai Anantrao Adhav versus Shivram in 1988, she cannot claim maintenance. Okay, so this was our section 125. Now 126 is basically nothing but a procedural part, like against whom the where the case can be taken place, that where the person resides. Say it, I'm done with the section 125 CRPC. Now I'm talking about section 126 CRPC. It's about the proceeding under 125 may be taken against any person in any district where the person lives, where he or his wife live, or where he lives with a woman carrying carrying or given birth to his illegitimate children. So in any of the places, the in any of the places, the case can be initiated, and the order for the maintenance will be given in the against whom the maintenance order has been issued. Suppose a court issues the maintenance order against me, so I should be present in the court, and that order should be present. Order should be given in my presence, and if I avoid such proceedings, then the court has right to give the ex parte order. Ex parte order means one-sided, ek tarfa order. Again, it can be challenged, but the law says a prima facie, and the initial part it happens in that. Now, section 127 CRPC. 128 is not that important. 127 CRPC basically talks about the alteration of maintenance or some changes. So in that part, either the amount for the maintenance can be reduced or it can be cancelled completely. And the procedures says that in section 125 CRPC, that if the magistrate feels that there is a change in circumstances, then he can alter the either he can cancel the maintenance order, or he can alter the monthly allowance, or or he can also alter the interim maintenance also, if the magistrate deems fit. And what are the reasons for such alteration? If the woman remarries, section subclause 3 of 127 CRPC says that if the woman remarries, or if the maintenance is paid according to the customary laws, I'm talking about the third period, or if she's talking about or she has surrendered her right voluntarily, in such cases there is uh, there is no maintenance given, there is no maintenance given to a person. But I will again repeat some one thing, that the important section is section 125, which is religiously neutral. Any person of any religion can go even today and ask for maintenance under section 125 CRPC, whether it is a Muslim, whether it's a Christian, whether Parsi, whether your customary laws allows you or it does not allow, it does not matter. You can still ask for the maintenance under section 125 CRPC. And the subclause 3 of section 127 CRPC only comes into the effect. It talks about the alteration. Alteration means if the judge feels that the woman has been given the proper maintenance according to the customary laws, and obviously the customary laws was changed, was just a second, I'm getting a message. Just so if the customary laws, if the customary laws are changed, or if she accepts it, then only then the section subclause 3 of 127 CRPC comes into the play. So now I've explained these parts, and now I'm open to the question answer box. Okay, so
Thank you so much, sir, for such an informative and enlightening session. So we will now be taking up the questions which we have received from the participants. So the first question is from retired Justice Mr. Nagendra Kumar, sir. Whether family courts has the jurisdiction matters Domestic Violence Act.
I have said this again, that the family court does not have the jurisdiction in the domestic violence cases, as it's a criminal matter. Although it was allowed, although it was allowed in one of the judgments in the last month, but as such, it's not allowed. They don't have the jurisdiction.
Thank you, sir. Moving on to the next question. The next question is from Mr. Pritesh. He wants to know what is the relevance of state statutory limit on maintenance provided to parents and wife when center has removed all kinds of limits from it.
Just wait, before moving to this, I would like to explain you something. See, first of all, these laws are made by the center. Okay, like if the center makes a law or CRPC law, okay, it makes the laws, and what the state do is it makes the necessary amendments according to their own according to their own practice, or uh, according to their own society. Like for example, like when the maintenance part was for section 5 in this section 125 crpc was 500 rupees. So there was many state amendments, like in mp, they amended the crpc for under their state amendment, and they increased the amount to rupees 3000. Similarly, the Maharashtra government, they increased the amount to the 1500. And again, one of the more amendment done by the MP government was uh, when you read the section 125 CRPC, what happened is that in that it has written the wife can claim maintenance, the minor children, whether the legitimate children or the illegitimate children, can take maintenance, and the old parents can take maintenance. But the MP government in 1998, what they did, they amended and they added the grandparents also, which is not there in the CRPC. So the MP government allowed the grandparents also to take maintenance from their grandchildren. So these state amendments are also necessary because it allows to implement laws according to their own state society. Okay.
Thank you, sir.
Moving forward.
So moving forward to the next question. The next question is from Ms. Anu Bhatnagar. She wants to know that what is your take on the implementation of the laws related to domestic violence? Do we need to follow stringent action to implement such rules and regulations?
See, Anu, I explained you in the mail also. See, what happened is that making a law is not important. Okay, the importance is the importance is the how you implement the law. Like I've given you the example, like the Environmental Act was made in 1986, the NGT was made in 2010. So you see, there is a gap of 24 years. So and when we see we have laws, we have so many laws from Articles 15 subclause 3 to Section 113B of Indian Evidence Act, Section 498A, the Dowry Act, the Domestic Violence Act. But it's of no use until unless the society changes. So it is important for the society to change first, and that's why I took good 15 to 20 minutes in the start to just focus on this societal problem and the attitude of the people towards women. So until unless we do not change, we do not change in that manner, the laws cannot be successful, and the laws will, uh, laws will only works as a punitive measures rather than the preventive measures or reformative measures, because it is the duty of the laws to, it is also a duty of the law to bring reform, just rather than being the punitive part. It is also to prevent a crime, to bring reform. It is also duty of law. But until unless we do not change and we do not change our attitudes towards women, I don't see it happening. Like you bring a strict law and things will change. I don't think so. It's going to happen.
Okay. Thank you so much, sir. Moving on to the question. So the next question is from Mr. Utkarsh Bilda. He wants to know that what is your outlook on the spurt of nuclear families or Section 125 in relation to parents not being able to claim maintenance from their children? According to you, will Indian society ever see that nature of litigation as a common thing?
See, every form of society, whether it's a nuclear society or or a joint family, they have their own pros and cons. Obviously, in the joint family, the chances for domestic violence is quite less because there are many people living together, and in nuclear family, nobody comes and sees such thing. And in another problem, another problem comes there is that the parents, because in the nuclear family, which became a trend in last 3 decades, like one son is living in one city due to his job, another children is living in another other city, and now the parents has to pick and choose that to whom they should go and visit. And whenever they visit, it's a new place, new environment. They take their time to adjust. They are old, and in such cases, obviously, when they faces abuses and when they see the domestic violence being taking place, they are unable to take strict legal actions to prevent such things. So obviously, and in coming times, the way we are going, sorry to say, we should not, one should not be that pessimistic in the webinar or something, but I don't see that happening in near future. Sorry.
Okay, thank you, sir. Due to the paucity of time, we will be taking only 3 to 4 questions more. And
Mm-hmm.
yeah, if anyone's questions are remains unanswered, then you can put those questions in the WhatsApp chat box, and our guest speaker will try to answer them at the earliest. Thank you. Sir, the next question is from Ms. Soumya Upadhyay. She wants to know that what is the ambit and interpretation of the term share household and domestic relationship?
See, I've talked about that section 2F, section 2 subclause F of domestic violence that defines the domestic relationship, and section 2 subclause S defines the shared household. See, in that what happened, that domestic violence, domestic relationship is in the DV Act of 2005. It says that when the two person lives together in a relation of consensuality, marriage, or through a relationship in the nature of marriage or adoption, or the family members are living together, it will be called as a domestic relationship. And this was the relationship, this was the term which actually held. When you talk about the interpretation, it was interpreted by the Supreme Court. I've said earlier also, in the judgment of Indra Kumar versus VK Sharma in 2013, Dhanulal versus Ganesham in 2015, the Khushbu judgment of 2010, the Veluswamy judgment of 2011, that it actually held the Supreme Court to interpret that term domestic relationship to legitimize and also the shared household to legitimize the living relationship. Next.
Okay, sir. So moving on to the next question, what are the developments suggested for the long pending inclusion of men as a victim of domestic violence?
See, yes, Article 14 says, Article 14, the second part of Article 14 says that every person has is entitled to the equal protection of the law, but it does not. But obviously, Article 15, subclause 3 again, provides special provisions for women. Yes, we need gender neutral laws, gender neutral laws, because we see the misuse of the 498A. We see the due to the personal vendetta basically, and to claim larger maintenance post divorce, the misuse of the section 13 of Hindu Marriage Act, the misuse of dowry laws, the misuse of uh, other women centric laws. So we need gender neutral laws. But see, first of all, you have to understand that the law becomes successful only when it is accepted by the society. Like when we see the gender neutral law, more than gender neutral law, another problem is that of the marital rape. So, and at present, I don't think the Indian society is matured enough to accept the marital rape as a crime. So obviously, obviously like before blaming to the government or judiciary, when we divide it into two parts, on the personal level, first of all we have to reform ourselves. Okay, only then these situations will come down. And also also on the duty of the police, the executive part, to ensure that the proper investigation is done in such cases, and the investigation is also done timely, so that the woman is not able to misuse the law, the way it is taking place. Yes, the gender neutral law is the need of the hour, but at present the maximum victim is the women. So it is the gender neutral law, obviously, like the obviously Section 125 also empowers the male to claim maintenance to claim maintenance from the wife if he is not earning. But to specifically make the gender specific law, I mean, it should the society. I would say it won't be a good idea at present. But yes, in future, it's bound to happen.
Okay, thank you so much, sir. So we'll be taking up only one last question. Sir, this question is from Ms. Teju Anand. She wants to know that if a person, either of the spouses is involved in like into the act of infidelity or flirting on social media, let's say on Facebook or WhatsApp, they're chatting and the same amounts to infidelity. So can the said act done on social media be made as a ground for divorce, though the said act has not been done, physically, as in like not in person it has been done. It has been done over the social platform. So the other spouse can take it as a ground for divorce.
In that, it does not becomes the serious ground for the divorce. Okay, it can be again. It clearly shows that these divorces are nothing. Sorry, these cases are nothing but the case of infidelity. There is a simple flirting. So the divorce has to, and it clearly establishes the fact that in future also the partner won't remain loyal to each other. So obviously these won't comes under the because the as you have said that both the partners has been caught infidelity, right? Hello. So this
No,
the
sir.
divorce
Sir,
has to be
not both the partners, either of the partner, maybe the husband or the wife. That is not clear that who was involved, but maybe either of them,
Mhm.
any one of them.
Either of the then obviously see if the wife then it is an adulterous relationship na. So again, under the section subclause 4 of section 125 CRPC, the wife is not entitled to claim maintenance. But yes, if the husband has done this part and the wife wants to, move out of the house and wants to break the marriage, then she is entitled for the maintenance. It's cut to cut clear.
Okay, sir. So, guys, with that, we would like to come to an end to today's session. I know the session was really very informative and thought-provoking one, but however, like as every good thing comes to an end, so with that, we'll come to an end to this session. But before ending the session, I would like to deliver the vote of thanks on behalf of the entire team of lexauxilium.com. I would like to thank Advocate Rahul Tiwari, sir, for accepting our invitation and joining us today for this session and helping our attendees to understand the ambit of domestic violence, what amounts to domestic violence, and what are the, let's say, legal remedies or provisions available to get a redressal against the same, or what are the challenges which are still remaining while implementing the laws which are related to domestic, which are prevailing in the country related to domestic violence. So with that, I would like to thank Rahul Tiwari sir for accepting our invitation and enlightening us on such an important topic, which is the need of the hour in today's era and in today's society. So we will be coming up with more such sessions in the near future. And keeping in mind this subject matter, we are also coming up with a free certificate course on criminal litigation and procedure. And the uh, said and the instructor for the said course will be no one other than our very own advocate Rahul Tiwari sir. So without not taking much of your time, sir, if you would like to brief about our upcoming course to our participants, that how it can be beneficial for them to join that particular course.
See, it's a criminal law course. It's been designed by me only. And earlier I had kept, earlier I had kept 13 lectures, but now I have increased to 16 lectures. I have included rape, mob lynching, blasphemy, section 154. The poster will be shared with everyone, and the cyber defamation parts, sedition laws. So I've covered all these parts. So the classes will take place on Saturdays and Sundays. It's a 16 lecture series. You will all the person attending the course and fulfilling certain conditions like every week the assignments will be given. Obviously I'll be always available to clear the doubts, and last night also I have written 28 mails to the questions. While you were guys were registering for the webinars, I had some 43 questions, and I gave replies to like 43. 31. I have mail, and last night I replied back to 31 mails. So I'll regularly update you. I'll regularly clear all your doubts. But the assignments, I will get 1 week time to complete the 2 assignments of the classes, which will take place on Saturdays and Sundays. And obviously there will be an 80% attendance criteria. And if you fulfill both the parts, only then the certificate will be issued by the law firm as well as an NGO. And obviously, the person having more doubts or being more interactive will be given the internship opportunities also. Okay, and it's a free of cost. So, already we have received close to 360 registration. And earlier I thought of keeping the batch size of 30, but I might increase the batch size. It's again in the consideration. So, obviously. You have the brochure will be given. You can check into it and just let me know. Okay.
Thank you so much, sir. So as sir has already briefed us about the course which we are coming up with, so it will be a free certification course, and all the details regarding the same will be released on the website of lexauxilium.com very soon. So keep checking our website for the update on the course, and follow us on our Instagram handle. And till the next time, adios to all of you. Bye bye.